Well, good morning, everyone. Appreciate you all being here, notwithstanding the weather outside. We don't have everyone here, but I think we have enough folks to start. I'm very pleased to welcome back to the committee the Information Commissioner of Canada, Ms. Suzanne Legault, and you have with you Nancy Belanger, who is General Counsel, Director of Legal Services, and Ms. Jacqueline Strandberg, Counsel Legal Services. We are embarking on a study. We don't know how long it's going to be yet, but we have a motion before the committee to embark on a study of the Access to Information Act, and we are so glad that you could come back and join us immediately after being here on Tuesday. Ms. Legault, and if you would mind introducing your staff to the committee, and then start your presentation. We'd be happy to hear from you as we embark on this endeavour.
Good morning, Mr. Chair. Thank you very much. I'm here this morning with Nancy Belanger. Nancy is the General Counsel in my office. So Nancy is responsible for any legal advice, but also she supervises any kind of litigation that we have and provides input in all of our investigative files, particularly the complex files, and generally provides advice about everything that goes on at the OIC. And I'm accompanied as well by Jacqueline Strandberg. Jacqueline is a counsel as well within Nancy's group. And Jacqueline was very instrumental in the production of the report that we're going to discuss this morning. So with that, Mr. Chair, I'll start my presentation. I have just very brief remarks. And I thank you and I thank the committee members for the opportunity to discuss my special report to Parliament entitled Striking the Right Balance for Transparency, containing recommendations to modernize the Access to Information Act. During my appearance before this committee this past Tuesday, I recommended that the number one priority for the committee should be the modernization of the Access to Information Act. After over 30 years of existence, the time has come to take bold steps to transform this piece of legislation. An eminent expert in the field of access to information, Professor Roberts, wrote the following in 2012. Around the world, our understanding about the importance of governmental openness has advanced substantially. We know much more about what works and what does not work in the domain of right to information laws. And we also know that the system of responsible government is resilient. Fears that the constitutional order would be upended by the adoption of this sort of legislation were overblown. There is a world of experience to be drawn upon while updating the Access to Information Act, and no good reason why it should not be done with boldness. Les recommandations contenues dans mon
The recommendations in my report, Mr. Chair, are instructed by international, provincial and territorial legislation. They're also informed by annual reports, model laws from around the world, reform proposals made by former commissioners and parliamentarians, and all the reviews of the Act that have already been done. The recommendations are also based on my own experience of having completed over 10,000 investigations during the course of my mandate. The recommendations are drawn from the highest standards and the best practices for access to information legislation. The recommendations are aimed at allowing the Canadian people to have greater scrutiny of government activities and decisions. And we're doing this by extending they would do this by extending the coverage of the Act to all public institutions, including those that receive funding from the government. The recommendations, Mr. Chair, are aimed at strengthening the information management framework to ensure that the government remains both accountable and transparent. The recommendations are aimed at ensuring timeliness in the processing of requests as well. As the first Information Commissioner aptly said, and that was Ms. Hanson, delaying access to information in effect destroys the purpose of the Act.
Aimed at striking the right balance between transparency and the protection of specific interests that require protection. They are consistent with open government objectives, such as the disclosure of information that support the accountability of decision makers and citizens' engagement in public policy processes and decision making. To maximize disclosure, exemptions should be narrow and focus only on protecting the interests they are intended to protect, no more. They should be, in most instances, injury-based, discretionary, time-limited, and subject to a public interest override. The recommendations are aimed at effective oversight based on key fundamentals, such as the ability to review all the records at issue and to issue binding orders. In fact, 68% of all the countries that have implemented an access law in the past 10 years feature an order-making model. In Canada, British Columbia, Alberta, Ontario, Quebec, PEI, and to some extent Newfoundland have binding order powers. The recommendations are aimed at aligning the Act with open government initiatives, such as publishing information that is of public interest, disclosing more information related to the repayment of grants, loans, and contributions, and requiring institutions to adopt publication schemes. Les recommandations visent l'introduction d'un régime.
The recommendations are aimed at introducing a comprehensive regime of sanctions to address actions contrary to the quasi-constitutional right of access. And finally, the recommendations are aimed at addressing a number of inefficiencies and long-standing issues with the access to information system. Let me give you a few concrete examples of issues that require a legislated solution. Firstly, in terms of the coverage of the Act, the Supreme Court of Canada determined that ministers' offices are not institutions covered by the Act. Decisions of ministers can significantly impact Canadians, however. Ministers need to be accountable to the Canadian population for the administration of their areas of responsibilities. And only a legislative amendment can extend the coverage of the Act to their office. And this is based on the decision that was issued by the Supreme Court. Secondly, in terms of information management, there is documented evidence of serious breaches by the public service of its obligation to create and preserve information of business value. Recent examples include the triple delete scandal in BC and my report on the use of text messages. Information commissioners from across the country recently co-signed a joint resolution, this was in January, and this resolution calls on their respective governments to adopt a legal duty to document.
Chair, delays are a frequent subject of complaints by requesters. On average, this represents 40% of the workload that my office deals with in terms of administrative complaints. There is a huge efficiency to be gained in the entire system for dealing appropriately with the question of timeliness. One case in particular is a salient example of the lack of discipline currently in the Act. Last year, we had finally a decision in a case that I brought to the federal court questioning the reasonability of a 1,110-day extension applied by the Ministry of National Defense. And although the decision from the federal court is expected to have a positive impact on timeliness, the current legislative framework is inconsistent with progressive norms. It is truly compelling to think that I had to take this matter all the way to the Federal Court of Appeal to have a decision that such a lengthy extension was unreasonable under the legislation. In terms of maximizing disclosure, the Supreme Court of Canada recently interpreted the exemption for advice to government in the Ontario Access to Information Law very broadly. The court's ruling extends far beyond, in my view, what must be withheld to protect the provision of free and open advice. the equivalent exemption in the federal law, Section 21, uses similar language to its Ontario counterpart. Section 21 was already considered, prior to the court's decision, as the Mack truck of exemptions. The breadth of this exemption must be legislatively narrowed to strike the right balance between the protection of the effective development of policies, priorities, and decisions on the one hand, and transparency in decision-making on the other. In terms of strengthening oversight, the Commissioner's ability to issue orders would ensure that the processing of requests would be more timely, would instill more discipline and more predictability, would provide an incentive for institutions to make comprehensive and complete representations to the Commissioner at the outset, would create a body of precedents that increases over time, and requesters and institutions would then have a clear direction as to the Commissioner's positions on institutions' obligations and requesters' rights under the Act. One of the most frustrating aspects of the work that we do at the office, Mr. Chair, is that we find ourselves re-investigating the same issues that have been dealt with many times by previous commissioners, instead of having a body of precedents that will actually provide clear clarification. And again, there is a huge efficiency gain if we don't have to re-investigate the same issues again and again. In order to assist the committee, I will provide in the coming days a written submission with reference notes on each of the 85 recommendations. I have provided a sample of what we're going to provide to the committee for Chapter 1 of the recommendations. We simply didn't have time to translate the whole document before today. But the idea behind this table, Mr. Chair, is to really provide the committee with an easy reference in terms of where the recommendations come from, where they were discussed before, and why they're there in the legislation, in the recommendations. I will also provide to the committee a backgrounder that will enumerate the previous proposals to amend the legislation since it's coming into force in 1983. In closing, I would like to reiterate that the changes proposed in my report are, in my view, long overdue and are urgently needed. Having a modern access law would assist Canadians in exercising their right to know. It would also facilitate the creation of a government culture that is open by default. In my view, unless we significantly modernize the Access to Information Act, we will not be able to effect this change of culture, which is absolutely essential to meet the government objective for an open and transparent government. And it would also re-establish Canada's position as a world leader in access to information. I strongly believe that the time has come to modernize this Act. We need a new Act, one that will pass the test of time, and one that will pass the test of successive governments. Thank you, Mr. Chair.
Thank you very much, Ms. Legault. We appreciate the fact that you've come again, and I'm hopeful as we go through the deliberations in the days and weeks to come that you would make yourself available to come back again should we have future questions in regards to some of the recommendations. So we'll now proceed to the questions. The 7-minute round. We have Mr. Erskine Smith. The floor is yours, sir.
Thanks very much, and thank you for the presentation and also the the thorough report, striking the right balance. My first question, I'll start at the beginning, recommendation 1.1, and the recommendation is that there be an expansion to all institutions that spend public money in whole or in part. And I just wanted to drill down a little bit. So is the recommendation that all institutions or organizations that receive funding from the federal government would be subject to the Access to Information Act? And how far do we read in part?
Mm-hmm. The idea with the recommendations in that part of the report is to do a couple of things. And one is to really have a principled approach to how we have institutions covered by the Act. Right now, we have a schedule that has a list of institutions. So The Governor and Council can define criteria and they can add institutions to the list. What we are proposing is to have a principled approach of criteria that would basically be used to determine which institution is covered or not covered. And those criteria that you have in the recommendations are really based on previous proposals or international norms. The other part of it is we felt it important to specify that some specific institutions really must be covered, and those are ministers' offices, prime ministers' offices, courts administration, parliaments administration, and so on, simply for the sheer amount of taxpayers' dollars it's actually located in those institutions and the necessary accountability that would flow from that. So,
Just to jump in to that point, obviously, where there's a great deal of public funds being spent, I just wonder, is there a de minimis application here where an institution or an organization just isn't spending a great deal of public funds? Because I note in your recommendations there isn't a de minimis requirement set out, so I wonder if you could speak to that.
well, that's a good question. I actually haven't thought about that. This is something that was proposed previously and that we felt was a criteria that was necessary. But what you're suggesting is a very interesting point in terms of looking at that specific criteria. I don't know if you guys...
Staying with recommendation 1.1, the third bullet point in the report says institutions that perform a public function. And I wonder, because that's an additional criterion, is the suggestion that it would apply to institutions that perform a public function even if they don't receive public funds or are subject to government control?
Yeah, that is part of the criterion. So we'd have to look at the various types of institutions that are federal institutions that operate in the federal realm and see whether they fit within these criteria.
And for the purposes of your report, there's not a working definition of public function. That seems to be quite a broad broad term, but is there, again, just to have a sense of what we're restricting the application of the Act to, do you have any sense of how we might refine that public function?
Mm-hmm. Do you have any sense? That's something that we'd have to really look into very, very specifically. These are very, very good points.
Moving on to, staying with 1.1, just is it in suggesting or proposing the expansion of the Act, and that makes good sense. More institutions that spend public funds should be subject to access to information requests and transparency. Is there any worry, given the existing delays in the system, that absent additional funding, we're going to expand the application of the Act to so many more institutions, and it's just going to create further and further delays?
Further and further delays, I don't necessarily think that would be a result of that, because parts of the proposals would be that each institution that's subject to the Act actually has strict timelines to respond to access requests. Where there is an additional funding that's required is that each institution has to have some infrastructure sufficient to answer to access requests. And it's difficult to predict how many requests each institution is going to get. CBC, when it first became subject to the Act, thought that it would get a certain amount of requests every month, and they ended up getting a large number of requests very quickly. Various institutions receive a varying degree of requests. Citizenship and Immigration receives over half of the total amount of requests, so around 34,000 requests. But most of the smaller institutions receive very few requests. My office receives maybe about 100 requests a year. So
to that point, in your experience, do organizations require dedicated staff to be responding to these requests? Because, again, if we're expanding the scope and application to a number of institutions and smaller institutions perhaps, is there any worry that they may not have the resources to properly respond?
It depends on the various institutions. A lot of the smaller institutions, a lot of the port authorities, for instance, receive very few requests. A lot of them receive no requests at all. Some port authorities will receive, a few, and the way that these are structured is they often have their general counsel that's responsible for access to information requests, or their corporate secretary, or someone is actually responsible for those functions. If you have an institution like Via Rail, for instance, they receive a few more, so then they may have to have a consultant. It really varies from institution to institution.
Moving to the next series of recommendations, 1.2 through 1.7, this is extending coverage to the Prime Minister's office, ministers' offices, parliamentary support or institutions, and even court support services. Can you, and I know those are all broad or various different organizations, so maybe stick to the Prime Minister's office or the minister's office. Can you give an example of a current document or a current set of documents that you think ought to be disclosed currently but aren't being disclosed, just so we have a working example?
Mm-hmm. Well, I think the best example was some of the records that were at issue in the Supreme Court of Canada decision that is referred to oftentimes as the Prime Minister's agenda. And really, we refer to this case as the Prime Minister's agenda, but there were other types of records in that case which are really of importance, I think, to Canadians. And these were minutes that were taken of meetings between the Minister and the Chief of Staff and senior officials in the Department of National Defence. And the only records of those meetings were actually notes of exempt staff. And the court decided on the current test that these records would not be subject to access to information. In my view, seriously, these were highly important records of decisions in the time of preparation for war. So they could have been exempted under national security exemption, but they should have been subject to the Act. And that was a really clear example, and that's something that's documented.
Thanks. Ms. Legault, thank you, Mr. Erskine-Smith. We now move to 7 minutes for Mr. Genereux, please.
Thank you very much. And thank you very much again, guys, officially on the record for being here today. Coming back twice in 1 week is impressive that you're able to do that. So thank you. I guess I want to, my 7 minutes, want to question, I guess, a bit of how your office is structured in that. So as we start to go through the process, I get a sense of that. Let's go back, I guess, 2006. I was reading in the report that's when the last, you don't say modernization, but that's when the Act was reviewed at the last. What was walk me up to 2006 to here, I guess, on kind of why we're doing this again and this time. And not that I disagree, but just curious as to your thoughts.
Walk you up in terms of what proposals have been made before, or
well, I guess
or the history? 2006.
Wasn't that long ago. Now to review the Act again in 10 years, how do you defend that?
Okay. Well, since the coming into force of the Act in 1983, there have been several reviews, and we'll provide that to the committee. In 2006, the previous government, when they came into power in 2006, they had promised to implement all of the recommendations of Commissioner Reid, who had actually worked with the previous committee and had produced the Open Government Act, and that incorporated a whole series of amendments. The government in 2006 actually passed legislation in the Federal Accountability Act, and that legislation contained a subset of some of those recommendations. So it increased the coverage of the Act to a lot of the Crown corporations, CBC, Canada Post, Via Rail, and agents of Parliament, my office, the office of all the commissioners except for the Ethics Commissioner, but the other commissioners are now subject to the Access to Information Act. So that was part of that reform. As part of that reform as well, there were some very specific either exemptions or exclusions that applied to all of those entities, and I talk about that in the recommendations. So that was done, and there was also a duty to assist that was put into the legislation. Aside from that, in the history of the Act, there was one other significant amendment, and I think it's in 1999, and that's when a criminal offense was put in. That's the section 67.1 in the Act, and that flowed from a private member's bill. But in terms of looking at other coverage, in terms of looking at the exemptions, in terms of looking at the timeliness, in terms of looking at the order-making power, and also the other thing that really was not part of the 2006 discussion, at the very least, and reform, was how do we modernize the Act in the context of open government by default. That's really fairly new, actually.
And so, sorry to cut you off. What was the implication then on your office at that time? Do you have to expand your office? Where did Crown corporations then have to go and hire additional staff dedicated to these ATIP requests? What's your thoughts on that?
We actually had to implement an access to information office in our office. I know that other agents of Parliament had to do the same. Certainly CBC had to do the same, Canada Post as well. So yes, they had to implement some infrastructure to respond to access to information. But, I think we have to look at it in the context of what are the responsibilities of public institutions. For instance, we all have reporting obligations under the Financial Administration Act for the way that we expend public monies, and those are considered to be normal. And I have a staff that deals with all of the financial responsibilities that we have because it's considered to be a necessary obligation. It's the same for access to information, in my view, when one becomes subject. If Parliament decides that this is something that is necessary, it's ultimately always up to the legislator to decide whether this is a necessary thing for public institutions or not.
Right, and also just wanting to make sure we're not going down a path where we're grinding certain institutions to a halt because now suddenly there's an influx of this. So just want to be careful with that. In terms of goals, have you set? There's a lot of average. You mentioned it. Citizenship and immigration takes up the majority of your requests. Have you set internal goals on where you'd like to get those numbers to, whether that be percentages, numbers of days, etc., for some of these recommendations?
What do you mean, numbers of days?
So would you like to get, maybe numbers of days isn't a good example because you have the standard numbers of days, but do you, percentage-wise, are you looking to reduce the number of requests? Are you going to see an increase in number of requests, I guess? What's kind of your benchmark in your office where you'd be happy with?
It's important to understand that the access to information requests are done to the public institutions that are covered by the Act. And the President of the Treasury Board is the minister responsible for the administration of the access to information requests that are made within the federal government. My office investigates complaints that are generated if requesters are not satisfied with the response they get. So the citizenship and immigration, there's 250 so institutions covered now under the Act. About 68,000 requests overall in the system last fiscal year. Half of that comes to citizenship and immigration. They have a low ratio of complaints. They are actually, in my view, supporting the system overall. If CIC were to do poorly, it would be a disaster for the access regime. So that's the bulk goes there. Then you have CBSA and the RCMP.
Okay, but obviously modernizing the Act, you have an intent to reduce complaints then? So what's, I guess, is there something internally? Am I up? My time up? No. Oh, okay. We'll come back to that. Thanks. Think about it.
It is, and the chair was busy doing several other things and was advised by the clerk. We'll now move to Mr. Blakey for 7 minutes.
Does that mean I'm getting more time too, or?
No, there was no more time
okay.
allocated, but I appreciate the insinuation. But your time starts now, Mr. Blakey.
You don't ask, you don't get, right? just wanted to come back to, I guess, in a very loose way, the recommendation 1.2 about expanding coverage to ministers' offices. But I guess on a more kind of general note, which is as access, as the number of institutions and some of those decision-making centers, I mean, you're absolutely right that ministers' offices are making important decisions, but I think there is a general tension, and I don't think an insurmountable one, between, you know, like as an amateur historian, you want to have the records there, but as people have more access to certain records now, it discourages actually making those records. And even with something like a duty to, and then you can never find out why that decision was made. And I'm just kind of wondering how we can be sensitive to that tension, to try and create records that the public could have access to, but still maintain what I think on the face of it makes sense, which is that, you know, when I'm in a meeting, for instance, I want to make private notes. I may have things that I don't want on the record forever. They're fleeting ideas. They're things that I just want to explore later that I'm not committed to. It really wouldn't make sense to have them be part of the record. And so when we talk about making people's notebooks accessible, now granted, if those are the only records of a meeting, then I think there's a far better case actually to make those accessible. So, you know, granted that there really ought to be some sort of record of the meeting and decisions, but how do you think we can proceed in a way, because I think often that tension is used as an excuse not to provide any form of access at all, and that's partly how we're getting to where we are, is that argument ends up trumping, and people say, well, don't we have the right to be able to consult and kind of have our own decision-making process, and won't you be impeding the good decision-making of government if we don't have that? So I'm just wondering how we could proceed in a way that recognizes that people need time, that some people think on paper, and they need to be able to have that process before they come to decisions. And so how do we do that in a way so that argument can't be used as a fig leaf for those that would just want to deny access for the sake of denying access?
What you're saying is something that we hear quite a lot. When I talk about changing the culture of government, it's exactly what I'm talking about. People actually have to understand that we are all of us, we're carrying a public function. We are working for other people, all of us, in everything that we do every day. And the other misconception is the Access to Information Act is actually structured in a way that what needs to be protected is going to be protected. Solicitor-client privilege, personal information, advice and deliberation. All of these exemptions are there for that specific reason. In the example I gave about the notes, obviously these notes would have been covered by national security exemption. There's nothing improper about that. You know, when people are covered and institutions are covered by access to information, it does generate a certain decorum. The decorum should not be that you don't take notes. The decorum should not be that you do not create records. But the decorum can be that you don't make disparaging comments about a colleague in your note, because those will be disclosed. And you will find that there has been quite a good discipline that's been instilled in the public service in the way that communications occur in the workplace. Those are good things, actually. But in terms of taking notes, yes, they would be covered, and they are covered for all of us within public institutions, and that is not necessarily a bad thing. Mm-hmm. We just have to hone up to the fact that these notes are part of the record. Now, they would be probably in many instances transitory records. So they're subject to an access to information request. So if they exist by the time that the access to information request is made, they are part of what's responsive to the request. But those would be, you know, unless they're really crucial notes that you need to put into your file, they would become part of the official records. And if they're part of, you know, transitory records that you're allowed to let go after a while, then that's fine. It becomes a question of whether that's a record of business value or whether that's a transitory record.
Right. Yeah. Yeah, I mean, it's just an interesting question. So I find myself thinking, well, okay, well, what would I do with the pages in my notebook? You know, I mean, I go to a lot of meetings, and I mean, is it, you know, so if those don't make it on the file because they don't, you know, because I'm not in the habit of tearing out sheets for my notebook. Now, I mean, under the current active, it's not an issue for me. I'm not covered, but it is. I mean, maybe it's just partly a learning process for me in terms of what that would mean. And even the format of my notebook, needing terrible sheets, I don't know, but
I received an access to information request for my notebook when I first became information commissioner, and I tend to doodle quite a lot. And there was a really nice drawing of a horse, I remember, and you know, I just said it's fine. It just gets disclosed. I don't mind.
Yeah.
It's people have to just you know grow into this culture of disclosure at a certain point. And if there are references in my notes about specific files and they're subject to confidentiality requirements under the Act, they get processed like that by the ETHI folks. If there's you know, notes of conversation with my general counsel, they can be protected under solicitor-client privilege. If there is personal information because I'm dealing with a labor relations issue, then that gets protected as well. That's the way your notes would be treated, the same as any other record.
Okay. Well, thank you. I think that's very helpful because I have a sense that that's going to be. I wanted you to speak to that at length because I think that's going to be a big part of the meat of what needs to be decided both here and then in the House when legislation comes forward.
It is a genuine concern. It is a genuine concern of people, but people have to understand that any record gets protected as it should be protected under the legislation. And that's why in covering institutions such as Parliament's administration, we're recommending to have proper exemption for parliamentary privilege. That's going to be crucial.
Okay, that's it. Monsieur Nassé, vous avez 7 minutes, s'il vous plaît.
You have 7 minutes. Thank you very much. Thank you, Commissioner. My colleague spoke to you earlier about the question related to processing information requests and the time frames. We were asking how quickly you'd like to see things being done. Do you have any particular time frames in mind? Could you talk to us a little bit about the complaints that are underway at the moment? What sort of complaint do you get on the most regular basis? You said about 40% of your workload is dealing with these complaints, is that correct? I'd like to hear a little bit more about these complaints, what sort of things are involved, etc. Answer. Well, a number of recommendations in the report aim to focus on this question, to make the way we handle complaints faster. And this allows me to answer Mr. Généreaux's questions as well, because he was also speaking about this matter. We have, on a regular basis, we get an average between 35 and 40% are administrative complaints. So they're dealing with the time frames they're asking for. They're talking about extensions, they're talking about answers that haven't been received from institutions. So that's about 40% of the work that comes in on an annual basis. We get about 1,800 complaints a year. This year we'll probably get more. Some years we get less. But I'd say on an average it's about 1,800 every year. And the 60% of the remaining 60% of the complaints is where there's a refusal on the part of an institution to give information. So these administrative ones, which are about the timelines, we manage to get through them fairly quickly. They're not the ones that stay on our books. The ones that take up the time are there where there's been a refusal to share information. So we have some 3,000 complaints built up under this heading. About 88% is where there's been a refusal to divulge the information. These are often quite complicated ones. Of those, there's about 400 out of the 3,000. So about 400 are national security matters. And there's about 400 are with the CRA. And then there's about 150 that relate to the CBC, Radio-Canada. And the rest is just a mix from different institutions. But they're basically where we're seeing the files come from. I've also got ones that are long-standing from quite some time ago. I came into office in 2009. And there were some of my books there that went as far back as 1997. So this year, I'm going to be closing the last file from 2005, 2006. I could certainly give you a chart that would give you a snapshot of the different years. So we've got to break down how long the files date back and so forth, and what the main categories are. That's the dashboard that I use when I'm looking at what cases we've got in our books. It gives us a really good idea of what's going on. The biggest problem at the moment is that there's almost a year before we can handle a refusal case when the information's not being given. Once we assign the file to an officer, it usually takes about 90 days for the officer to process it. Obviously, there's outline ones that take longer. There might be some files that we get that are 20, 30,000 pages long, and that takes us an awful long time to do, and that's understandable. But there's also some that are very small, that take less time, that are perhaps less complicated. So that might give you a little idea of what's happening. Question. As regards these refusals to divulge information, are these complaints usually based on refusals from various departments? Do you think is there usually good reason for this refusal? I'd like to get an idea. Are they usually grounded? Answer. Well, in terms of these administrative files, if it is we get ones where the department hasn't respected the Act. So in the Administrative Act, there's about 80% of the cases, then the people are right to complain because the time frame hasn't been respected. In terms of where there's been a refusal to share information, it tends to be about half and half. For the past couple of years, we are trying to sort files. We've got a new category where we can say that it's dealt with, it's addressed, and we're not saying that the complaint was correct or that it was incorrect, but it's just we say that it's been dealt with. It's what we're using is almost a conflict resolution approach in these cases. It's a kind of mediation to try and get through the files a little quicker. So we have one where we can say, yes, there was good reason. There wasn't a reason. But we can have these ones where they say they're dealt with, and we're going from this mediation perspective. It's a third category, and that changes things a little bit. But usually, when it comes to refusing to share information, it's about half and half, whether they're well founded or not. I'm looking at the clerk. Because I was wondering if we would be able to get information on this data. Would you be able to give us your dashboard, as you called it? Would you be able to show us some information about which departments usually come under fire more often, which ones are targeted more often? I'd like to have an overview of it. Another question then. How do we fare in comparison to other countries in regards to access to information, click complaints and so forth? I understand it can be very complicated, but I'd just like to have a few ideas nonetheless. Answer. Well, I haven't done a study on this. What we have in terms of comparative studies is the work that Law and Democracy, the Law and Democracy Group, and there was an evaluation of Access to Information Acts. And that's obviously a study that's based on particular criteria, based on particular legislative frameworks. It's not really talking about the whole context. So it's quite difficult to compare one country to another. If we look at countries that have progressive legislation, this doesn't necessarily follow that they're the ones where there's more divulgation and more sharing. For example, in Holland, they might have very good legislation, but in terms of managing the system, it doesn't fare very well. In Mexico, they have a very high-tech system that's in place. They introduced legislation in 2002. So they're doing very well in terms of their IT. You can make a request to an institution for information. The institution uses the same IT platform to give its response. You can use the same platform for making complaints and so forth, and they've got quite tight time frames for giving answers. But I don't know if they actually go through things in such a thorough detail as we do to see whether what the institution chose to share or not to share is appropriate or not. So they have some sophisticated elements, yes, but other places have less sophisticated elements as well. In Canada, we have lots of documents as well because we are very good at information management. In Mexico, before President Fox, there wasn't a lot of documentation. So it's very difficult to compare which one is doing the best. I'm trying to explain this if it's useful. Perhaps we have a look at what happens in the provinces. And when you're going to be doing your review, I would encourage you to invite the commissioners that have this order-based model. And because we have an ombudsman model, but in the provinces, some of them have this order-based model. And that you'll see there's some real efficiencies to be made in terms of handling complaints and so forth.
Time is up, and thank you, Madame Legault. Before I get accused of being very liberal with the time, I want to now go to the 5-minute round, and we'll start with Mr. Kelly.
Okay, thank you, Mr. Chair, and thank you for attending our meeting. We appreciate it. So with respect to resolution by, in dealing with an expanded requirement for public entities to document matters including decision-making, deliberations, this type of thing. How do you see that impacting on on cabinet confidentiality and the concept of cabinet government, where cabinet must, surely in its deliberations will have disagreements, but at the end all must mutually support its decisions? How would you see an expansion of public access to deliberation to impact cabinet confidentiality?
It's very important to understand what we're proposing because a lot of the time there's a misunderstanding about what we're proposing. So right now, under the law that exists now, cabinet confidences are described very, very broadly. Very broadly. For instance, any record that contains anything that's described in the whole description definition of cabinet confidence can be excluded as a cabinet confidence. In our investigations at this time, we are not allowed to see the records. We see a schedule, a brief description of the records. Without seeing any records, overall, in 14% of the cases of cabinet confidence investigations, we find that it was improperly applied. Overall, historically, at the OIC. So that's without seeing any of the records. What we also see with the current definition is things like dates of cabinet committee meetings not being disclosed because of cabinet confidence and then being published. The definition, what we're proposing is to narrow the scope of the definition of what is a cabinet confidence such that it really protects the deliberative process that occurs within cabinet. That's the aim of the recommendations, so that we properly protect what needs to be protected, but we don't have a definition that really catches so much that it then becomes a shield against disclosure, and then there's no oversight. And what we're recommending...
If I may, cabinet deliberation is not something that you actually want to, you want to just make sure that the definition is there to properly exclude cabinet deliberation from the scope of
and what I'm recommending is that it would be a mandatory exemption, which means that if it is a cabinet confidence, it shall be exempted.
Okay, thank you.
But that I would be able to review whether it is actually a cabinet confidence that's being claimed. So I would have the ability to review the records. Now, given the sensitivity of those records, what I'm recommending is to apply the same restrictions that we have for national security, and that is that it would be a limited number of investigators in my office that would be able to do this work.
Okay, thank you. Now, in a time of when we are entering deficit, what do you estimate? And I understand when until we are sure that and have agreed on which recommendations are going to be adopted and understand the difference in scope of what the access to information may look like. But do you have any idea at this stage what you think a properly funded regime would cost?
I don't know. It really would depend on what happens in terms of the processing of requests. I must say, though, that in all fairness, what we have now in terms of the recorded costs of how much it costs to process an access to information request, this is data from the government. It's $1,000 per request. That, in my view, is very high. And I think it's because of the way that we administer this legislation. I have an example that I'll report upon in my annual report, which is not unusual, where I have something that's completely redacted, where in fact at the end everything should have been disclosed immediately, but yet that request went through a redaction process, it went through an approval process, it went through a consultation process with another institution, it led to a complaint, I have to investigate it, I've now, trying to resolve it. That, sir, should have been just disclosed immediately. And I really believe there's a large inefficiency reflected in the costs. So
that in fact that you need a larger budget, you need just more effective tools to deal with your.
I think there's a lot to be said about a proper culture of openness by default.
That will not change overnight, but that's a great thought. We'll now move to Mr. Saini for 5 minutes. Then we'll move back to Mr. Genereux, and we need another Liberal after that. So if somebody could let me know who that is, that would be great.
Thank you very much, Madame Legault. It's always a pleasure to hear your comments. I wanted to talk about recommendation 4.5, but I wanted to put it into context of 3.6. You say here that the information... Just because your mic is not good. We'll fix it. I think I'm being silenced. The Information Commissioner recommends that a third party is deemed to consent to disclosing its information when it fails to respond within appropriate timelines to a notice that an institution intends to disclose its information. I don't have an issue with that comment. What I have a little bit of trouble of, and maybe you can highlight this, is when you talk about the Information Commissioner recommends when consultation has been undertaken with another government, with a consultant government that does not respond to a request within 60 days. You just mentioned earlier that certain governments and certain countries don't have the level of data management or information management that we do. So being a trading nation, being a nation that has a great sort of interest in global affairs, my worry is that if a request is made to another government that doesn't have the capacity, not because they're unwilling, but they don't have the capacity in terms of their infrastructure to deliver that could impede the government in other areas. So I just want to know what your comments on that were.
And I agree with you. We were very mindful of that in the report. And what you'll see is there's actually two distinctions in the recommendation. One deals with when you are consulting with a government within Canada or institutions within Canada, where actually most of these, all of the jurisdictions in Canada, they're all subject to access to information laws as well.
I'm not worried about in Canada.
So that's where that if you don't respond, then you're deemed to have consented. It only applies to Canada. for international jurisdictions, what we are recommending is to seek consent if it's reasonable to do so. And the reason we put that there is because we did a study a few years ago in terms of these consultations, these international consultations. Most of them are done with the United States. And so that's reasonable to consult, and then to see if you receive an answer. But in other jurisdiction, it's not reasonable to do so for various reasons. Diplomatic relations with Iran, when we didn't, or Iraq, when we didn't have diplomatic relations anymore, or whether there's actually no infrastructure there for us to consult with, which was also an issue that was raised during our investigation. So the distinction is made, and it's only in that context. And I tell you, it does happen to us quite a lot in investigating those files, and that's why we put that there. And it applies a lot. We don't get responses from national institutions in cases of historical records. We get a lot of complaints dealing with archival records, and a lot of the time it involves police investigations that occurred some time ago, or other types of investigations, and we need to seek consent, or the institution needs to seek consent, and the institutions in the provinces or territories don't respond. So we asked them to send letters and so on. So it was really meant to address a very specific issue, and that's why we are recommending to split those between national and international for specifically what you're raising.
The other point I had was that in recommendation 4.9, you said that the Information Commissioner recommends a statutory obligation to declassify information on a routine basis. And I think in your recommendation, I think you wrote 10 years is when that should be. The question I have is just to sort of elucidate on that matter, is that you also mentioned that you would be applying an injury test. So I'd like you to help me understand what the injury test is. And also you mentioned there that you would determine if the information still had enduring value. What do you mean by enduring value?
It would be based on what the library and archives, the archivists, each institution has to have a disposition authority. We all have to do retention and disposition authorities for our information holdings. To give you a very simple example, in my office, because we do investigations, we have some investigations where our retention requirements are 2 years. We have some that are investigations of enduring value that we have to send to library and archives. This has to be done with the archivists. So it's not something that institutions decide themselves. They have to get this retention and disposition authority with the archives. So that's the way that is settled. The declassification is really based on the Bronskill decision, federal court, where the judge, in a context of Tommy Douglas file, basically recommended that this is something that the government should look into, so that when files are sent to library and archives, that they're at least, sometimes these files contain human sources, and those need to be protected forever, and that's fine. But there's a lot of historical information in there that is of real value for Canadians, historians, and they should be declassified. They should be sent in a form where my office doesn't spend a lot of time investigating these files. They should be in a format that are ready to be disclosed to the public. And this is something you might want to hear the librarian on, because I think he might have, Monsieur Bertillon might have a few thoughts on that, because my office and his office have a lot of investigative files together, and it's something that we should declassify for Canadians, for historical value.
Okay, thank you. We're well beyond the 5 minutes there. We go back to Mr. Genereux, please, for 5 minutes.
Great, thank you again. Personal information requests. So if I have a constituent that wants to know what the government information they have on them, your recommendation, them come to you, put a request in, but they have to go to, if it's RCMP, if it's CIC, there's no central location right now where they can request that, correct?
No.
Right. So if to go and to get to that level, what do you see as some of the hurdles to, Joe citizen wants to find out what every organization that would fall under the Act, how they would do that? What do they still, under what you're proposing, would they still need to go to every organization, request that information, and then it's compiled according to the Act?
Mm-hmm. There's two things here to your question. First of all, if someone makes an access request for their own personal information, it would be covered by the Privacy Act. So I invite you to ask this question to the Privacy Commissioner, because it's not something that I looked at. What's covered under our Act is if someone makes an access, this is where the two acts interact, by the way. What my colleague was talking about, the seamless code, it's the exemption for personal information. That is where the two acts intersect. And so what we see in our files is someone will make a request to, a lot of the times, to their employers, and they want to have information about everything having to do with their labor grievance. So their request under the Access to Information Act will deal with everything about their grievance as opposed to their personal information. So it's a broader set of it's a much broader request under the Access to Information Act, and that would have to be treated under the Access to Information Act in any event in terms of where the information is located. Now, I think you'll have to ask the Privacy Commissioner if he's put any thought to your question, because that's not something that would fall within my purview.
Yeah, and understanding that for sure. I guess there was a part of a Liberal campaign promise was to create that central database, no fee website where you could go, and I'm just trying to get a sense from you if that's part. What's your interaction with that? What flags are raised? Something that you can help us kind of work through to get to that?
It's really not something that I have studied or looked at all, because it's what I deal with is related. There are exemptions for personal information, but the requests that we deal with are not about people's own personal information. So in principle, to have a central database of all personal information, I don't know how it would be done or how it would work. It's something, as I said, you need to ask my colleague.
Okay.
But it wouldn't mean that people would not still make the same access to information requests under the Access Act, and they would still, those records would still be part of that. So I don't think it would alleviate any responsibilities under the Access to Information Act or any processing of requests where there are necessary exemptions for personal information. I don't think it would diminish our workload on the access side. I'd be surprised. I think it would really be dealt with under the Privacy Act and their workload.
Perfect. Quickly then, before my time's up, you referenced the Financial Administration Act, and I saw it in a few places here, that one area you say it's listed in the Financial Administration Act, others it's forget the other word you used, but it's a little bit different than listed. Hoping you can break that down to which these institutions and Crown corporations that specifically for me being new here, I'd like to see exactly which ones we're talking about. I pulled up the Financial Administration Act yesterday, and it's a big act, so I'll leave it at that. But if you can get in a bit more detail for us would be wonderful. If you want to speak to some of it now, go for it. Otherwise, you could add some of it to probably this report that you're doing. Great for me.
But also, given the questions that have been posed this morning, we'll do more work for the committee on the coverage aspect, given some of the questions. So I think that would be helpful for the committee, and so we'll do some of that work.
Okay, that's it for Mr. Genereux. We'll go to Mr. Saini now, who I think is willing to share this spot.
Madame Legault, you took some time in your report to differentiate between the ombudsman person versus the order-making model. And from what I've read, to me, I think part of the frustration you have is because you have so many cases that are similar that there should be some sort of precedent-setting model where if cases fall under that precedent, it would be easier to adjudicate. You've also talked about the cost of processing a case. So, I mean, budgetary constraints are everywhere, but I'm just wondering if we were to adopt the order-making model, do you find that your office would be more effective, more efficient, and in terms of the ability of your office to deal with those matters which are a little bit more complicated than the routine matters you have, because every office has routine matters which consume a lot of your time. That time could have been saved because precedents would be set using the model that you suggest, and you could spend more time to dealing with other issues where once those issues are dealt with, then they could become precedent-setting models. Can you maybe elaborate on that, please?
Yeah, this is a very good question, and I can give you very, very concrete examples. You know, I was telling you that 40% of our files deal with administrative matters. Well, if you're able to just say to the institution, you shall disclose the information by this date, it's a lot more efficient than having to do an investigation. And by the way, the Federal Court of Appeal case for the 1,110-day extension, it's not because we didn't try to mediate that with the department. We tried extensively to mediate that with the department. We could not get the department to agree to a date for disclosure. It had to go all the way to the Federal Court of Appeal. Now, in an order-making model, that would have been settled within days. We would have just, you know, looked at the situation, looked at how many records were involved, looked at the consultations necessary, and if we could not come to an agreement with the institution, we would have just ordered the disclosure by a certain date. This is what happens in Ontario, for example. And you will find, if you speak to my colleague in Ontario, that they don't have issues with delays because the institutions know. They have to, you know, it's a reasonable mediation process. Once the institution is in default, it does happen, it will continue to happen. But the institution comes to the oversight body and there's a conversation about when this information can be disclosed, and then there is a decision that's made and the information is disclosed. That's the first step. It really solves a lot of those issues. So that's one thing. The other aspect of real efficiencies in an order-making model is the mediation aspect, and that is key. Right now, when we do investigate refusals to disclose information, we do try to mediate. But you have to understand that in an ombudsman's model, it's the same body that mediates or tries to negotiate something that makes the decision at the end or the recommendations. So there's no real mediation privilege around that discussion. And you will find also with my colleagues that have order-making power that mediation component, if you have an order-making model, is a lot more effective for two reasons. One, you can really have mediation privilege, i.e. if you don't agree, there's a separate adjudicative process with separate parties. In our model now, we do try to negotiate as in an ombudsman model, but there's no real protection or privilege for that conversation. And in an order-making model, if you don't mediate, then it goes to adjudication. And that's a lot more costly, it's a lot more time-consuming. And the last efficiency is that the institution has the burden to give all of its representations to justify the non-disclosure at that time. In an ombudsman's model, if they want to give us sort of, you know, not very strong representations, they know that ultimately I'll have to take it to court. So if the government does not want to disclose, the incentive in an ombudsman's model is to not do a very solid job to justify non-disclosure. But in an order-making model, that incentive is completely reversed. And the burden is truly where it should lie. And that's the main, like, these are the three huge differences and efficiency component to that model, which are truly in sync with the quasi-constitutional right of access.
So that pretty much chews up the 5 minutes, but we're going to have some extra time, so I'll be able to get back and make sure everybody gets their questions in. So we'll move to Mr. Blakey now for the last round, which is 3 minutes, and then I'll open up the floor because we'll have about 20 minutes left, and anybody who wants to ask more questions at that point in time, please indicate to me. Thank you, Mr. Blakey.
Thank you very much. In the beginning of Chapter 1, you talk about how quasi-commercial entities, special operating agencies, and public-private partnerships have become increasingly, and I'm quoting, of course, common modes for governments to carry out their their business. And I'm wondering if there are some precedents that you can speak to for ensuring that access information that deals with third parties like P3 would protect legitimate commercial interests, but not create another black hole. So if part of the goal of reform is to eliminate those black holes where information can be shoved, are there precedents or are there ideas at least about how there could be some oversight for that?
We investigated some cases recently. This issue of the public-private partnership. We're getting into a lot of subcontracting for the work that's being done within government. So Public Works does a lot of big contracts. The big contracting companies subcontract to a lot of other smaller entities, and we're finding it's getting more and more difficult for people to have access to those records. And we had quite a difficult investigation. We were trying to establish that Public Works is still responsible for those records, but as you move through third and fourth subcontractors, it's very difficult to get the records. So that's one issue. But in terms of protecting third-party commercial information, we have put in specific proposals to amend Section 20, and the reason that we're recommending proposals here, it also deals with appropriate protection with trade secrets, commercial, financial information, but also the Act, the way it's done right now, it leads to a lot of inefficiencies in the investigations because there's about 4 grounds for refusing disclosure. They all overlap. Some of them are mandatory, some of them are discretionary, and so our investigations are very complex because we have to go through each step. Everybody quadruple banks all of these exemptions. So, and this is really our experience in all of our investigative files with third-party commercial information. So we're recognizing the importance of protecting it, but we want to really streamline the way that exemption is crafted so that it really simplifies the investigation while protecting the information.
Thank you.
Keep going.
Have I got a little more time?
You do so.
Yeah. Okay. Yeah, I mean, I guess maybe I'll just use that time to make a comment that I do think it's important, especially in light of all the contracting out of government work that's going on, that there be a way to get access to the information, at least to be able to make a value for money assessment. I mean, that's one of the advantages that we have when things are done in-house. We can evaluate how much is spent on it. We can get a sense of what Canadians are actually getting for the money spent, and then as we kind of hire other organizations to do that work who say that we can't access information about how that work is getting done and what it costs, there's a serious cost to Canadians in terms of being able to evaluate the quality of that work. And of course, there are other costs because you end up losing the in-house capacity and people who actually know what's involved in doing the job and then can make reasonable assessments for government about whether the price that they're paying for that work makes sense, whether what they're being told needs to be done is actually something that needs to be done, or whether that contract is being padded. And it seems to me that having access to information, protecting legitimate commercial interests, but I think that's probably a lot narrower in scope than it's been traditionally defined, is important so that this House and Canadians themselves can do the work of evaluating the value for money that they're getting. So, it's certainly something that I would like to see addressed in our study.
Well, I'm sure you'll ask very pointed questions on that in the future. So that chewed up that little bit of time. But right now we're in unofficial time territory, and as I mentioned earlier, anybody who would, if you would like to indicate to me that you've got some questions, I've got Mr. Bertina, Mr. Massey, Mr. Erskine Smith, and I know Mr. Kelly. So why don't we start on this side of the table, and then we'll move to Mr. Kelly, and then we'll go back over here. So whoever, Mr. Bertina, you haven't had an opportunity yet, so we'll start with you.
Thanks very much. Thanks again for the presentation. I want to go back briefly and have you expand on the notion of culture change and whether that has to do with a kind of entitlement where people in governance might take the attitude, well, it's really none of your business, leave it in our hands and we'll look after these matters, as opposed to, and I hate to refer back to my previous experience, but there were institutions who had failed to file information, and it was butting your head to try to get the information, and I'm wondering whether a newer government with fresher faces might be more ready to actually go through that culture change. Could you just comment a little bit about what you're after in terms of culture change?
Very good question. We do live in a Westminster-style parliamentary system, and if you look at our parliamentary system historically, there's a lot of secrecy. We grew up as a democracy in that kind of system, and it's interesting when you look at history to see that parliamentary debates used to be held in secret in London. And in fact, the mayor of London, somebody called Hansard, actually decided to publish these, in a rogue manner, because they thought that the public should be made aware of what parliamentarians were discussing in the British Parliament. And then the person was actually jailed in the Tower of London, but eventually they got published. And look, all of your discussions are now televised. So that's what I mean by a culture change. We have to go through the same culture change in the public service, in the way that we administer the Access to Information Act. It's very, the way that people administer the Act is they will look at a record and they will say, okay, Section 19 applies, Section 21 applies, Section 23 applies. Oh, but I can also apply Section 20. And, oh, I think Section 69 is probably, it's probably also covered by Section 69. And Section 15, and maybe Section 13 as well. We will see cases where we have like a whole slew of exemptions applied. So the way we apply it is whatever possibly applies as an exemption to disclosure. Because we're risk averse in the public service. We're afraid of disclosing something that we should not disclose. So there is that culture that exists, for sure, in the public service. So what do we have to do? I think that there is a very significant difference with the new generation, the millennials. I think all of us who have children who are in that category really truly see the way that people work. And I think we're going to have to, as public institutions, profoundly change the way that we communicate our information from the government, because our millennials, not only Canadian citizens, but our public servants, they want to share this information. They need it to work. They work this way by using a whole broad source of information. I also think that we need to do that because sharing information with the public today's time actually creates an innovation society, and I think that we have to do that as well. The whole idea behind open government in the US particularly was really based on creating an innovative society. Why? Because we have cut a lot within our public service, and information and innovation occurs a lot outside of the public service, and there needs to be this interaction so that we maximize the opportunities for innovation. So I truly believe in that. And yes, I know people think I'm a little bit of a Pollyanna perhaps in this, but I don't think that necessarily has to be the case. And if you speak to people from the Swedish government, you will find that their public servants' perspective on what needs to be disclosed is very different than ours. So they have 250 years of experience with access to information laws, but their culture of disclosure is very different than ours. And as part of your study, if you want to actually speak to some representatives here from the Swedish Embassy, you will find it tremendously interesting in the way that public servants deal with disclosure of information, and goes a lot to some of the comments about how do we administer this efficiently, because the way they administer it is a lot more efficient than the way that we administer it, because they actually put a lot of the responsibility and the accountability on public servants directly. They make decisions on disclosure. They don't have a centralized process. They don't have approval processes. It doesn't get reviewed by communications people. It's a lot more simple. And
Okay.
so there are things to think about in the change of culture, and there are examples in other jurisdictions. So we need to really think about not just the risks, but the opportunities of doing something like that as a country and as a public service.
Okay, good. So, Mr. Bertina, that was a solid question that used up the better part of 6 minutes. Mr. Kelly.
Thanks, Mr. Chair. Again, on this general recommendation toward greater disclosure of or greater availability of documentation and the requirement to document decision making. I listened to Mr. Blakey's first round of questions with interest, and your own anecdote in particular about having to disclose your horse doodling and whatnot. And the thought that I had then was, how do you guard against if we all agree that anything that you ever create, whether it's a sketch of your notebook that might contain your own doodlings or whatever you might commit to paper, is and ought fairly to be part of anybody's access to information. How do we protect against an absence of context when information is disclosed, and frivolous or phishing type requests that people may be encouraged by the knowledge that you never know what you're going to get when you see somebody's notebook. That frivolous or vexatious requests will arise from that, and that information disclosed will lack context and not be understood properly.
There are two things in your question, and I guess I have 3 minutes to answer that. I'm just going to... So the first thing is contextual information. There's nothing preventing anyone from disclosing the context of the information if you're concerned about it. You can disclose more. There's nothing preventing you from disclosing more, ever, in any of the legislation, so long as you're not disclosing something that you're not allowed for, human source or something. But you can provide more information in the context. That's not something that you should necessarily be worried about.
I'm sorry to interrupt. It's difficult to convey the context and elements of what is going on in a room when a document is made just from a document.
Such is life. It's really the way that our right is constituted, and I think we give, and I'll be very brief on that. I think we give very little credence to Canadians in terms of how they understand things and so on. I think we get a little bit overly defensive in Ottawa, and perhaps we consider that some of our information bears more importance than it does to the average Canadian. But anyway, so the other point that you made about frivolous and vexatious, we do make recommendations in the Act around those things based on our experience. We do make a recommendation that there would be some discipline put in the Act for frivolous, vexatious, or abuse of the right of access. Is something that does not exist in the Act. Oftentimes what we see is institutions use assessment of fees to sort of deter this type of request. It's not something that I think is appropriate, but frivolous, vexatious, or abuse of the right of access I think is appropriate. The other thing that we're recommending is that there would be something to deal with when some requester makes multiple requests within a very short period of time to the same institution. We see that every year. And the institutions completely cannot absorb these kinds of, it's almost like a bombardment of institutions. We saw it with CBC. There's one institution this year that's going through the same issue. They have nothing in the Act that they can use to get extensions of time. There's nothing I can do either. There's nothing I can The only thing I can do is work with them and work with the influx of what ends up being an influx of complaints as well. But that's something that really does need to be put into the legislation with proper parameters. I fully agree with that.
Okay. So are you okay, Mr. Kelly, with that? We have, I think we've allocated up until about quarter after, but I see a couple more people on the list that would like to ask a few questions, and I'd like to ask a few questions. So if you're okay to stay a little bit longer, then we'll do that, and then we'll use whatever time we have left over for our committee business. So we now go to Mr. Erskine Smith.
Great. So I wanted to pick up on this notion of inefficiencies. And the inefficiency I take being the exclusions largely, to get to the bottom of the exclusions versus exemptions. So you would have an opportunity to review exemptions and determine whether the exemption is proper, but with the exclusion, you might have a whole fight about the exclusion. And the example you provided was fully redacted, went through many processes, a complaint, et cetera, and there are inefficiencies built into that. On the flip side, and maybe you can flesh this out, the PMO, the minister's offices, the parliamentary support organizations, these are currently excluded, and if we go to an exemption rather than exclusion model, are there the resources to review the additional information that you'll necessarily have to review to make the exemption determinations as to whether the exemptions are proper?
If I understand correctly, well, yes, depending on how many requests that generates in the system. We don't know. If the administration of Parliament is covered, how many requests is Parliament's administration going to get in a year's time? We don't know. You might want to speak to Mr. Bosk to see what kind of demand he thinks that they would get in terms of assessing, getting some kind of assessment of what that would mean. Of course, the more information is disclosed publicly, usually the less information is being requested through access to information. There's usually a period of adjustment, I'd say, as well. CBC was a perfect example. Large number of requests, and then it really tapered down.
And I guess I'll move over to administrative penalties, which we actually haven't spoken about today, but there are existing sanctions and there are proposed sanctions, and maybe you could give us just a little bit of background as to what value the proposed sanctions would have and what effect you think they might have and why the current sanctions are insufficient.
The section on the sanctions is really based on our experience with some very specific investigative files. As I'm sure all of you know, anything that bears a criminal conviction means that it really is competing in terms of resources with the RCMP's resources, who would be the body that those cases are referred to. In some instances, the level of severity is different, and to have a full spectrum with administrative monetary penalties is probably more in line with the severity of some of these offenses. The other thing that we're proposing is some amendments in terms of these infractions that exist within the Act, and that's really based on our investigative experience. There were some gaps there that we felt needed to be addressed. And the other key component is when we do refer a matter to a police body, the Act predates some significant case law in that respect, and it puts my office and it puts the people who are the target of these investigations in very difficult circumstances. And it should be aligned with the way that it's done in the Lobbying Act, which are more modern pieces of legislation.
Just one last quick question. You mentioned earlier the example of notes in a meeting, and they were excluded, but that ought not to be the case. In fact, that should be subject to a national security exemption. Given if we adopt the exemption rather than exclusion model, do you foresee a great deal more information being publicly available, or do you think instead that rather than being excluded, we're just going to find the same information is exempted?
It really depends. Some of the institutions that are not covered right now, like NAV Canada, I think that would make a tremendous difference in terms of accountability if they were covered. In terms of cabinet confidences, I think that we would actually proper oversight. If we narrowed it, there would be more information that would be at least available for disclosure. It would be a different test, it would be a different exemption, be subject to, if these recommendations are applied, to a public interest override. So I think that there would be more information that would be subject to disclosure. What we're proposing is a scheme where, disclosure would be improved, in my view. So even if there are new institutions that were not covered, that would become covered, information that was excluded that would not be excluded, the scheme that we're proposing would actually have a better balance. It wouldn't mean that everything would get disclosed, because not everything should be disclosed, and I'm the first one to say that. But it would be a more appropriate balance in terms of protection and disclosure.
Okay, are you satisfied with that, Mr. Erskine-Smith? Okay,
so much.
So we'll move on then. The last person I think that has some questions here is Mr. Massey again. The floor is yours, sir, for some questions.
On a combien de temps?
How much time do we have?
Tout à l'heure, vous avez mentionné.
A little earlier, you talked about some of the challenges faced in a specific case where there was a refusal to disclose information. You started a process, there was some mediation, some dialogue and so forth. At the end of the day, you had to go to the courts to move things forward. I'm a fairly curious person, and so I'm just wondering to myself, what was the department involved at that time? Because I'm not aware of this actual case. And could you also tell us a little bit about the decision-making process? Ultimately, who decides not to disclose the information? Answer. I'm not sure which one you're talking about. We have a number of cases before the federal court at the moment. Let's just say the worst one that you've seen. Answer, well, there's not so much as one that's the absolute worst. Let me tell you how things work. When there's a complaint that comes to our office where there's been a refusal to disclose information, what we do is we try to resolve it. We try to speak with the institution, and there's this period of mediation, we could call it, where we talk and we have a dialogue between the investigators and the analysts and, on both sides, and we have this discussion. We try to look and see what should be disclosed, and see if we can find any common ground, things that ought to make sure that the relevant information is protected properly as well. And we can put, if we can reach agreement in some areas, we can put that aside, and then we look at the areas where we can't agree. And if we don't manage to reach an agreement, we call this a Section 35, and that's the first step. We make a formal request. We ask the institution to make formal representations. Maybe it be an ADM that would do that. And if we don't reach an agreement after that, we issue a formal letter from the Commissioner, and that goes directly to the Minister or the agency chief. Because sometimes it's not the minister, sometimes it's the agency chief. And there, at that time, the minister will have the opportunity to make the decision to decide whether, based on our recommendations, they will disclose the information. If the institution and the minister decides not to accept our recommendation, not to disclose it, then the person who's made the original request for information has the right to go to the federal court. And they can do that of their own accord, or I can also do it on their behalf. In general, we do manage to resolve, to settle our cases. It takes a lot of time, but we do generally get it done. There's only a very small number of cases that actually go to the court. And when it goes to the federal court, it's often because there's a difference in interpretation. I'm not saying one person's right, one person's wrong, but there's just different views as to how the matter should be interpreted. And to my mind, the cases that are before the court, they're perfectly legitimate. We're working with an act, and I think it's perfectly legitimate. As you know, it's not as if it were maths or pharmacology. You can't just say 1 + 1 is 2, or this is what this particular drug is. So it's a legitimate question of interpretation that goes to the federal court, and then we wait to have the federal court's decision. And just a little follow-up, if I may. Once again, how many cases do you have before the federal court? We have 3 files that we ourselves have taken to the federal court. There's one that's on passengers. on the list, the no-fly list. So it's about the number of people that are on the no-fly list. We have one that's about documents that are in the PMO, and we have the one about the long arm, the long arm registry. There are other files that we're involved in, because perhaps there's third parties that have taken files to the court, and sometimes we're an intervener in those cases. Thank you.
So as the chair, I'd like to use my prerogative, if it's okay with my colleagues here, to ask a couple of questions as well. I listened to the debate, and I want to thank you very much for your succinct answers in this. I just want one quick, if possible, clarification. It seems to me there was a theme about efficiencies being found when it comes to departments just changing their culture and just being more proactive, or meeting schedules, or whatever or whatever the case might be, when it comes to just actively disclosing the information, which would, I think, solve a lot of your issues right up front. And I'm just wondering, has anybody done a study on the cost? Because it does cost money for people to yes, it costs money to do an access to information request, but it also costs money to follow a schedule and meet the publication of documents. Has anybody done an analysis on the cost-benefit analysis of either system?
No, and they're not necessarily the same. I.e. what would be published through a publication scheme is not necessarily what's being requested. The only thing that we've done is we've looked at what data has been proactively published under the Open Government Data Initiative, and the types of access to information requests are very distinct. The only place that I can see that we may be able to get data for the committee is in Scotland, because in Scotland they really did have to put publication schemes, and there was an oversight process for publication schemes. So they would have before and after kind of information in terms of cost, in terms of what was published and things like that. So we can look to see if there's good information. But remember, we used to not publish any information about travel, hospitality. We published some information about grants and contributions. So these, in the 1990s, became almost like publication schemes. And what we find in other jurisdictions is that publication schemes are based in part on those kinds of proactive disclosure. So there was some cost associated with that. But that's something that the government decided to publish proactively because they were access to information requests. So.
Yeah, well, agreed. Agreed. I'd be very curious to find this out. So now we're going to Scotland and Sweden, it sounds like. But, the second question I have for you is the generation gap between that you're talking about. I mean, you talked about the millennials. So I interpret that as a generation gap. And if we took a look in the departments that the Government of Canada has right now, and this is, I know there's some issues here within Parliament as well that we're talking about, but in the bureaucracy, the generation gap between the millennials who are likely working in frontline or mid-management positions right now versus some of the folks that might be a little longer in the tooth that are working in senior management positions, and there's a cultural generational gap that's there versus a culture of sort of secrecy or the old way of doing things, and the new culture, the millennial way of doing things, which is a much more collaborative, open, transparent process. And I'm just wondering, is there any good examples that you can give us of where we might start looking to see how we can get government to be more open and just kind of change that culture within the bureaucracy?
Something, this is not something that I've looked at. I mean, I know that the blueprint 2020 of the previous clerk was really based on something like that, more collaborative information. And they did a lot of consultation in terms of how this could be done better and things like that. So they would be, the Privy Council office dealing with blueprint 2020 would probably be the best people to ask that question to, because they've done a lot of work with public servants.
Okay. And my last question for you on behalf of the entire committee is, you've already indicated to us the Swedish model would be something that might be of interest to this committee, and you've talked a little bit about in Scotland how they might have some before and afters that would address the previous question that I asked. Through your the document that you've published, is there anyone that you feel this committee should be meeting with insofar as how models, not only provincially whether it's from the other federal governments around the world, other state or provincial level governments in various other countries, that we should be taking a look at and incorporating or bringing witnesses in or studying the models that they have, both from a positive perspective as something that we can do, and not necessarily only from a positive perspective, but also as a cautionary perspective. We can take a look at some models that aren't working to make sure we don't go down that road. And if you could submit that, I don't expect you to have a fulsome answer to that question right now, but if you could get that to this committee in the very near future as we try and delineate who we need to talk to or who we should be talking to, I think your recommendations would be very important and very insightful and very helpful. So on behalf of the committee, I want to thank you and your staff for coming here today. We're now going to adjourn for a couple of, certainly, Mr. Ursula-Smith.
I'd forgotten just to ask, I think you'd already had it in your notes, but I'd asked about the two issues in relation to the expansion of,
Yes.
and you had mentioned to report back, so just make sure it was on your list. Great, thanks very much.
I think that's already been taken care of. So there is an active dialogue that goes on to make sure all of those things that we ask for will be coming back to the committee. So I want to thank you very much for your time, and I do sincerely hope that it should be need to speak to you again before our study concludes. We'll have that opportunity. So on behalf of the committee, thank you for coming this morning, and we'll now adjourn. We'll suspend for a few minutes, and we'll go in camera to discuss future business.